Thank you very much. And we'll go ahead and, Mr. Colantano, if you want to go ahead and make your presentation at this time.
Yes, my name is Michael Colantuno. I'm a local government attorney. I was invited as a neutral witness, and had I been more timely today, I would have spoken earlier. I appreciate your flexibility in letting me speak now. Although in the interest of full disclosure, I represent local governments as my primary business, although I also represent the nonprofit corporation that operates the Tourism Marketing District in San Diego, so I bring that perspective as well. But I'm trying to present in as neutral a fashion as a lawyer is capable of. The major issues that local governments experience when dealing with the shared economy in housing are land use, taxation, and health and safety issues. I'm going to touch on each of them briefly. On the land use side, the big question is this a commercial use in a residential zone? And if so, is it permitted? Zoning ordinances treat all land uses as either expressly permitted, you can do them, expressly forbidden, you can't do them, or conditionally permitted, you can do them with a permit. Auburn, which wants to promote this use because they don't have enough hotel rooms to support their economic development aspirations, chose an interesting compromise. You get an over-the-counter permit, provide notice to your neighbors, and if nobody asks for a hearing, there's no hearing. But if a neighbor does ask for a hearing, then we'll conduct a hearing on the permit. And that allows us to very quickly separate the good neighbors from the bad neighbors. There can also be private land use issues that arise, like whether or not you're consistent with the CC&Rs for a common interest development, whether you're violating the terms of your lease. There are landlord-tenant disputes. There can be boundary and easement disputes as well, particularly when in the older parts of the state where the boundaries aren't as modern and driveways are shared and those sorts of issues. And while those private disputes can be resolved by private dispute resolution and the courts, that's expensive, and people often come to local government looking for a government solution rather than private dispute resolution. On the tax side, the issues that come up is first, the business license tax applies in most cities to all land uses, whether they're legal or not. So you may be familiar with the fact that in the medical marijuana dispensary disputes, local government won a lot of cases because the dispensaries had violated the business license ordinance. We didn't get into whether Medipot was a legal use or not. However, most local governments use the business licensing process as an intake to City Hall and screen for compliance with all of our regulations to enforce and educate the regulated community, I would say. Second issue is that the bed tax, which you've been talking about quite a lot. The bed tax is either authorized by a statute that this committee, one of these committees has purview over, which is the Revenue Tax Code 7280, which is an authorizing statute. Charter cities have direct power under the Constitution to impose such taxes, and they do. They're quite similar across the state. They're based on a model ordinance that circulated a couple of generations ago. And typically they impose a tax on an operator for those who provide lodging for compensation for fewer than 30 days. Those are the key concepts. The information technology transformation of the world that we live in has raised interesting questions under bed taxes. One of those questions is now pending in the California Supreme Court in a case called In Re Transient Occupancy Tax Cases. And the issue there is, are online resellers of hotel rooms who take distressed inventory for traditional hotels and sell them through a different channel at a discount price obliged to pay the tax on their retail, what they get in the door, or on the wholesale price that they pay to the traditional hotel? What the industry has typically been doing is collecting a fee on their customer that matches the TOT on the whole retail rate, but only remitting on the wholesale rate, pocketing the difference. Some question whether that's a fair business practice, et cetera, et cetera. That's in some ways an unrelated issue, but I know that one of your chairs had an interest in it, so I mention it. The other issue that comes up for us in taxation is that because of Propositions 13, 218, and now 26, we can't make any change to our tax ordinances at the local government level that creates a new taxpayer or increases anybody's tax in any way ever without voter approval. Our tax ordinances have become frozen, and it requires voter approval every 2 years or every 4 years to change them. And when we live in an economy that changes daily, when great creative people do new and interesting things, our ordinances necessarily lag behind. Auburn has a rule that their bed tax only applies if you're letting 3 rooms or more. None of us can remember why that distinction was made when this ordinance was written right after World War II, but there it is. And we can't fix it without going to our voters in 2016. So we're allowing the use now, but getting no revenue off it, except to the extent that it drives the general economy, until we can get that tax on the ballot in 2016, when my expectation is that it will pass without controversy. We worry about taxing the online resellers. which we need to amend our ordinances to clearly do, because they are very threatened by the prospect of us attacking what they view as their business model, and we expect them to come into our cities with a lot of campaign dollars. And that can be very disruptive. In a town like Auburn with 13,000 residents, 6,000 voters, 30 grand is a very big number in a campaign in our community. It might not be noticed in Mr. Manchin's community or Mr. Ting's community, but we will notice it in Auburn. It will make a difference. So taxing the online resellers is a scary prospect for our community. Taxing this business model is less so because they have needs to cooperate with us. Health and safety concerns, the kinds of things my council member was a little polite in describing how painful the process was for her and her colleagues. They wanted to promote the use. They introduced an ordinance that allowed this use throughout the city, including the R1 zones, and they had a room full of happy people. Second reading was a room full of people wanting to keep commercial uses out of the R1 zone. They had a room full of unhappy people. So they amended the ordinance and gave a new first reading to exclude the R1 zone. Then they had a third hearing, which the first group showed up again, and they were unhappy. And we ultimately got to a place where the city adopted an ordinance allowing the use throughout the city, but had to promise the R1 quality of life defenders that we would have a vigorous code enforcement program to protect them from the following kinds of concerns. Parking, which is an issue in a Gold Town community, Gold Rush era community. Noises, it's the party house problem. Loss of privacy, particularly on small lots. Loss of housing, an issue that members of your committees have spoken to more articulately than I can. And then impact on neighborhood character. Another concern from the health and safety perspective that's unique to local governments is that if we get a call for service into our police department or our fire department, we need a responsible business owner to talk to. And if you're living in Hawaii and letting a unit in town that you inherited from your mom and don't want to live in, you're not real helpful to us at 2:30 in the morning when we've got a problem property. So one of the things we want to accomplish with requiring the hosts to interact with local government is to give us a cell phone number so that if we need it at 2:30 in the morning, we can get it. Most of these issues that I've been talking about today, from my perspective as a lawyer who has to divide things between legal issues, which are my responsibility, and policy issues, which I'm glad to leave in the hands of people who are brave enough to run for office, these are mostly policy issues. We can forbid commercial uses in residential zones, or we can allow them. We have that power. It's up to us. We have the power to tax, but it's cumbersome because of the need for voter approval. I should also point out that we have a robust set of enforcement tools available to us. Every violation of a municipal code is a crime, and theoretically we could take it into a criminal court, which would not have the patience for it because they're dealing with what they view as real crime. We can bring civil lawsuits, which is really expensive, and we have to only do it when it's really important and when we expect to be able to recover our fees. And we have administrative mechanisms that look an awful lot like parking tickets. So we do have the ability to enforce all these rules. That's all I have for the committees, unless they have questions of me. Thank you.
Thank you very much, Mr. Colantano, and all the presenters here. Any questions or comments from the committee? Mr. Ting.
Thank you. Had a number of questions. Thank you, Mr. Colantano, for your presentation. I was interested in your legal opinion, or legal question was, have you seen cities across the state start to amend their codes to update it given the recent court rulings that have occurred where cities have been, frankly, losing cases around the difference between what they have to tax the wholesale price or the retail price?
This is what I call the online reseller issue. The only community that I know of, and people are flying below the radar on this, people who are proposing ordinance amendments to reach out and touch the online resellers are doing it quietly because they don't want to invite the campaign activity. But San Benito County has adopted an amendment and got away with it. Others are looking at it. The advice I'm giving my clients is if you bring a bed tax to ballot for whatever reason, clean up the definition of operator so that it plainly reaches the new economy. Some of my clients are thinking about doing it proactively. Some of them are waiting for another reason, and a lot of them are waiting to see what happens in the Supreme Court case because maybe we won't have to.
Great. And just as a follow-up question, given the fact that you have multiple local jurisdictions with local TOT laws, do you see a role for us at the state level to bring more uniformity and consistency in this area?
I'm a local government guy, and I always worry about statewide solutions that cost us indiscretion. Having said that, I think it's fair to recognize that because of who you are and what you do, you have resources that we can't begin to assemble and shouldn't have to assemble. I'll give you one example of a collaboration between state and local government that I think is quite effective, and that is that you can contract between a city's revenue arm, one of our tax collectors, and the Franchise Tax Board and the State Board of Equalization to share data. Therefore, if a business is reporting Schedule C income to the state and doesn't have a local business license with our city, we can get that data from the state and use that data to enforce our own taxes. So I think the information collection that you're capable of and information sharing with us that's consistent with taxpayer confidentiality and our other obligations as government, that kind of a strategy strikes me as less likely to be threatening to local governments' views of their autonomy.
Great, thank you. Then I had a question for Mr. Arvalo and Ms. Louie. You mentioned at this point that you haven't legalized home sharing or Airbnb. Was curious regarding whether you're doing any particular kind of enforcement at this time.
We are doing enforcement. It's complaint-based. So if we hear from a tenant, landlord, or resident of an adjoining property that the units are being rented out, code enforcement will open a case, and we do have a number of open cases.
Some of the challenges that we discovered as part of this conversation were that some of the complaints come in as a simple noise complaint, and the resident may not know that it's because of a unit that has been rented on a short-term basis. In fact, in our case, single-family homes are the biggest generators of short-term rental noise-related complaints, as opposed to condos or apartments, as one might think. That's the case in our particular community. And because if you rent a home, you can have a bigger party, it just kind of is part of the business.
Okay, great. And given, I believe you're echoing your concern around rent-stabilized housing. Obviously, that's a concern in San Francisco as well. As you went through your deliberations, did you see a conflict between these types of products and the ability to preserve rent-stabilized housing?
Sorry. Rent stabilization in our community is a high priority. And one of the things that we're going to do subsequent to this is we do ongoing education to property owners and to tenants of rent-stabilized units. So we're going to update our forms and have disclosure forms when a tenant signs their lease agreement at the very beginning. They will have, almost like when you get a medical disclosure form at your doctor's office, it will say, you are hereby notice that you are taking a short-term rental, a rent-stabilized unit, and as a rent-stabilized unit tenant, you are not allowed to participate in a short-term rental platform. Mm-hmm. So all of those things will be brought in motion. We're also going to update the definition of short-term rental in our existing ordinance to clearly define that.
But I guess, did you believe, or do you believe that that HomeAway or Airbnb or VRBO, that having legalizing them would actually impact your ability to maintain your rent-stabilized housing stock?
If it's legalized, it has to be legalized in a way that it doesn't jeopardize current leases. And I think Maribel touched on it earlier, where not all, but many of the people that are living in the rent-stabilized buildings have low income thresholds, so they may be using the online shared housing model to subsidize their income, but in the long run they can end up losing the rent stabilized unit because they're violating their lease. So I think that if taking a step back, while we're saying no now, we know that cities are living things, and no today is not no 5 years from now, and that whatever models and whatever discussions we have to evolve and create systems that, if we do implement a program that enables this type of business, then we would have to put in protections that help educate people to not look for the short-term dollar at a real high risk of losing your unit. A lot of the landlords have strict contracts with their rent-stabilized tenants, to have an excuse to bump somebody out of their unit and return that unit to market rate is a major incentive for them. So it's a real cautionary process.
Great, thank you. My last question was for Mr. Augenstein. And as you know, the Chronicle recently reported just an update on the number of individuals who had filed. And given that the program just started, I think it's about 400 people had either filed or were in the process of registering with your office. Given the other thousands of property owners that are listing their homes, what steps are you taking to go register the other couple thousand? Are the companies cooperating with you, working with you to identify those individuals so that we can get them all licensed and registered?
Sure. Well, the first step has really been to get the word out as far and wide as possible to both hosts and website companies about what their obligations are under our local law. So we've done that. Our website, we think, has very clear instructions. We encourage all hosts to look at our website, www.sftreasurer.org/hosts, to find out what they need to do to come into compliance with our office.
And then I guess if say a year from now you don't make much progress, what would you go do? Enforcement? Would you work? I mean,
that's a decision that I think we would face. We would take if and when we face that question in the future. I would note that the transient occupancy tax, it's a third-party tax, meaning that it is considered the government's money from the moment the guest pays the host or website company. It is really the local government's money at that point, and it's held in trust by that third-party tax collector on behalf of the government. So we take all tax collection very seriously in the city of San Francisco, but I think we particularly want to pay attention to third-party taxes because that really is, we feel like the government's money that needs to be remitted to the government in full.
Thank you.
Thank you, Mr. Ting. Mr. Chow.
I believe one of the panelists has touched on this briefly, but the argument has been made that short-term rentals tend to take rental units off of the market and thereby driving up the housing costs. And what is your view of short-term rentals such as the Airbnb rentals affect the existing housing stock? Ms. Powers?
Could you repeat that last part of your question, please?
What is your view or sense of how these short-term rentals impact the housing stock?
So I'm a small community, a little bit unique. We're not West Hollywood. We have 13,330 people. Our homes tend to be a little more expensive than our neighboring areas. We do not have, our vacancy rate for our rentals is very low. Our ordinance is not allowing room rentals in apartment complexes, so apartment complexes aren't going to be affected by this. And you have to be a property owner, I believe, as Mr. Chow said before. Sorry, David. You have to be an owner of the property. In order to be able to advertise and promote on Airbnb. And so you have to live there. It has to be your property.
Got it. What about the rest of the panel?
The challenge that we see, it's merely supply and demand. It's pretty basic. We do have businesses that are specifically zoned as hotel for transient uses, and then we have our residential uses. And if the residential uses are being taken offline for any other type of activity, it's going to shift the market and it's going to put a greater burden on the housing stock that we have. West Hollywood, we have great demand for our housing, affordable housing, our market rate housing. The prices are going through the roof. Our greater concern, and I think if we were to move forward and look at compromises in the future, it's really going to be at systems that control our affordable and workforce housing. I think some of the market rate housing that's coming online now, that's less of a concern because that's a kind of a different plateau. But for now, units in West Hollywood are very scarce, and if you take them off of the market, the residential market, and you put them in a commercial market, that affects us.
Thanks.
Thank you, Mr. Chow. Any further questions or comments from the committee? Seeing none, thank you, ladies and gentlemen, for your testimony here today. I'd like to open it up for public testimony. If there's any members of the public who wish to address the committee, now is the time to do so. Seeing none. Any closing remarks from members of the... Oh, there was one? I apologize. The microphone over there. Thanks, Kevin. Right behind you. He's got it right there for you.
Good afternoon. My name is Lauren Burrell. I'm a Deputy County Counsel at Sonoma County, and I'm just here to emphasize the significance of this issue in our county. It's estimated that we have approximately 2,000 Airbnb or VRBO rentals in the county at this time, which is obviously a huge, significant amount of revenue that we're not able to collect at the moment, in addition to the fairness of rental properties that are paying TOT taxes. And we've been discussing kind of solutions to these issues, and a couple of things that Sonoma County have considered are we intend to require lodging operators to post their TOT certificate number on any advertisements so that renters know that they're doing business with good citizens. And we'd also we intend to include notices within property tax bills to inform property owners of their requirement to pay TOT in case they rent their properties out on these websites. So thank you very much.
Thank you. Seeing no further public comment, any final closing remarks from the committee? Seeing none, I would like to thank the local government committee and staff, as well as Mr. Ting and the Revenue and Taxation Committee and staff for this joint, very important, I think, informational hearing here today. And Mr. Ting, do you have anything else you'd like to add?
I would just like to echo my thanks as well to both our committees, both our staff. I think we had a very informative hearing with a broad range of testimony on clearly a very important issue in many of our communities.
Thank you very much, members of the committee, Mr. Ting, and this meeting is adjourned.